as someone who I hold as, being a loyal husband, a proud father. Number 3 is a lawyer, right? I think of myself as a lawyer. It's part of my identity. I think of it as, a part of who I am, right? But in the profession, we have a significant crisis, what I call a crisis of disaffection, right? That people are unhappy in their work as lawyers, that we have a disproportionately high substance abuse rate in the profession. We have a disproportionately high suicide rate among all professions, right? So lawyers as professionals are facing challenges, facing a lack of purpose and meaning in their lives and in their work, right? So I see these crises and sort of tee them up and in the book and sort of say, well, how did we get here, right? What are sort of the roots of some of these crises, right? And are there times in the past when the profession faced crises like these and tried to address them, okay? Now, we have faced moments over the last 50 years or so when the profession was asked, where were the lawyers, right? Why weren't lawyers standing in the way of illegal conduct, whether it was Watergate, right? Or a scandal. Remember the SNL scandal? I mean, how quaint a little scandal that was. It was only several $100 billion, right? The Enron scandal, right? Where were the lawyers? So we've had these sort of crises of professionalism, crises in the profession. And we've said, well, what do we do? A lot of hand wringing, right? A lot of questions. Well, we need to teach ethics in law school, which, thank you, President Nixon. I teach legal ethics in law school. Maybe it's a full employment plan for ethics lawyers, right? We teach ethics in law school now. Oh, we tweak Rule 113 to have a report up and to report out, right? We make some change, but not too much, right? So these, we've had a sort of cycle, a lather, rinse, repeat kind of cycle. Something happens in the profession, right? We make some changes around the margins, and then we, go back to business as usual, and the next crisis comes along, right? So I said, okay, well, was there a time when we did face some similar crises and made significant changes along the way? I submit to you that there was, but before I tell you about that time, I want you to think about what the institutions, what you think about when you think about the legal profession, right? What are the institutions of the legal profession, right? Well, it's bar associations, it's law firms, it's law schools, it's codes of ethics, it's bar exams. You might even think about, public defenders and legal aid lawyers, a public interest bar. So these critical institutions, right, are the things that we think of when we think about lawyers, right? Bar associations, bar exams, law schools, law firms. Well, in reality, all of those institutions we created between 1900 and 1920 or so, right? So before the late 1800s, right? How did lawyers practice? How did they become lawyers, right? One of the first law schools, if you'd call it that, was in Kinderhook, right? Early 1800s, which was basically a glorified law office, right? Not even as big as the Justice Center, with a couple of lawyers who had a penchant for mentoring young students, right? Litchfield, Connecticut, Tapping Reeve, starts one of the first official law schools. Again, glorified law office with a couple of interns, essentially, right? But how did lawyers become lawyers? Well, you interned for another lawyer, you were an apprentice, which was a glorified Xerox machine, right? You just copied things longhand, right, for the lawyer, okay? So the law firms were, not even WeWorks, right? It might be a couple of lawyers who shared some office space, one or two, right? No law firms, right? New York City had a kind of bar association in the first half of the 19th century. It was really just a law library, okay? No codes of ethics. So in the late 1800s, right, we start building these institutions, right? 1878, let's see, where's Northwest? I think it's that away, right? Saratoga Springs, 1878, the wealthy elite lawyers who summered in Saratoga Springs said, hey, you know what? We need to start an American Bar Association, right? People who went to Saratoga Springs to catch the baths and the cool breezes and the traffic, they created the American Bar Association, which was all male, all white, right? No African Americans. In the early 1900s, 3 African American men sought to apply for the ABA. They got admitted into the ABA and then said, wait a minute, you're African American. And their membership was stripped of them, right? Stripped of their membership, right? When the ABA found out that they were not white, okay? Bar associations start getting created. We have one of the first local bar associations is the Association of the Bar of the City of New York, which is now City Bar, right? Was created to break the Tweed Ring, right? Was created to inspire the rule of law, right? And lawyers who formed that, like Sam Tilden, said, we need a bar association in the city of New York to ensure that New York City stays as a center of commerce where the rule of law applies, right? Where you can't just buy the judges as they did, right? And clients and lawyers who wanted to change things knew that in order to win a case, you had to buy off the judge. And, no one wanted to, unilaterally disarm until the leading lawyers of the city with names like Sherman and Sterling and the Couder brothers, right? They came together in the city bar to break the Tweed Ring, right? To promote rule of law. We also have, in the post-Civil War era, increased immigration, increased migration and urbanization, right? And for the first half, or the first, for the bulk of the 19th century, right? It was pretty easy to become a lawyer if you were white and male and could work for a few years making nothing or even paying your lawyer to serve as your mentor, right? And then, a judge could admit you. We start getting very simple requirements. The Indiana Constitution says anyone could be a lawyer if they're white and male and can vote, right? Anyone of good moral character can be a lawyer, right? So we see very loose restrictions on entering the profession. And some analysts have said, well, the American economy needed that, right? Needed an open profession made up of men who were white. We needed an open profession to help the economy grow. But then what happened when we see the increase in population, in immigration, in migration to the cities, the ranks of the profession start to grow, right? And by the 1890s, 75% of all lawyers were the native-born children of native-born parents, right? 75%. So not even just, not even first generation, right? About a decade later, we see, particularly in the cities, that immigrants start to become lawyers, right? And that's when the bar really starts to crack down, right? Saying we need rules, right? We need a code of ethics, right? We need bar exams. We need to restrict access to the profession, okay? Now, so we put in the codes of ethics, but it doesn't quite work as they want to. We still see the profession growing, more immigrants become lawyers, and profession looks at the American Medical Association. American Medical Association has clamped down on medical schools, right? Saying, we want to make it more difficult to get into medical school. We want medical school to be harder. We want medical exams, medical boards to be more difficult because we want to restrict who can be doctors. We want there to be fewer doctors, okay? Over the course of just a few years, the AMA reduces the number of graduates of medical schools in the United States by half, right? And the legal profession says, you know what? We want what they're having, right? We want the same sort of restrictions. And how would you make the profession harder to access, right? Well, you might require there to be educational requirements prior to going to law school, right? You might impose requirements on law schools, right, that are costly for law schools to maintain, like having a full-time faculty and having law libraries, right? Having good facilities, right? You can make the bar exam more difficult, right? You could do any of those things and it would make it harder to become a lawyer. What the legal profession does is all of them, right? So we've got, schools that are catering to the immigrant population, working nights, having night classes, weekend classes, right? The American Bar Association partners with the newly formed American Association of Law Schools, created in 1900. In the 1920s, starts imposing these requirements, right? Educational requirements to get into law school, more requirements for law school, for accreditation, and then bar exam on the way out, right? 70, because of these let's say, while these restrictions go into place, 70 law schools closed. And they were law schools that catered to women, that catered to African Americans in the South, right? 70 law schools closed. 69 of them, right, were non-ABA accredited law schools, right? Because the burden of complying with the accreditation requirements, right, was too great, which because of that, it restricted access to the profession. So we also see with the ethics rules, the canons, there's nothing about enforcement of the canons, right? And that's one of the problems. There's no real punishment for violating the canons. And so the second bite at the apple that the profession takes is through law schools, right? In the 20s, is to make law schools more expensive, more difficult to get into. And you can read, as I did, the records of the conventions where they start talking about how to make law school more difficult to get into, how to make it more restrictive, make it more costly. And there's a lot of talk about, well, Abraham Lincoln wouldn't have been, discouraged from going to law school. He would have worked his way through law school. He would have been just fine, right? But there's also some darker stuff in those, in the proceedings, right? Including one lawyer who claims to have reviewed the records of ethics complaints, right? And says, well, I've reviewed the records of these ethics complaints. And really, the problem is, and forgive this, but this is from the transcript, it's really these Russian Jew boys, right? It's these immigrants. It's these people with the culture and the ethics of the shop floor, whose parents sell scraps, right? Scraps of cloth on the streets. And they have these large families, and they save up, they determine which one of their children has the best chance in life, and they support them, and they support them through law school, right? And that's not fair to the good American boys who know how to play by the rules, who know what's fair, and have a sense of American traditions and democratic values. And so we've really got to rein those values in, right? We've got to make sure that folks going through law school, right, or getting into law school, are trained appropriately, and don't have the values of the shop floor, okay? So let's go back. Remember, these are our institutions that still make up the profession today, right? This is their history, right? Same thing, we could talk about the canons, trying to restrict contingency fees, trying to restrict advertising, because who needs to advertise their services? Those people who don't already have clients, those people who might serve people who are injured on the job or by a railroad, right? The railroad's already got its lawyers. Those lawyers don't need to advertise, right? So we're going to restrict contingency fees. We're going to constrict advertising. We're going to restrict sharing of fees with third parties, right? Because in a lot of immigrant communities, there might be someone who is in the community, and they use language, the touters in these immigrant communities who are, stirring up litigation in them, right? Who are they stirring up litigation against? Elites, the clients of the elites of the bar, right? So we're going to restrict lawyers from sharing fees with third parties, right? So there was a sense of consumer protection, right, in these rules, in these institutions, for sure. There was a sense of promoting democratic values, for sure, right? There was a sense, and the very same transcripts who say, ugly things also say we want to bring people into the American experience and American democratic values. There was a sense of that, right? As strained as it might have been. So I try to sort of go through the values of these institutions and try to see the bright side of them and what they might look like today and tomorrow, and come with what I think are sort of three core values for the profession that we can, change these institutions in positive ways, right? Number one is true professionalism, right? True professionalism. And I go back to the notion of the framers and the small r Republican value of disinterestedness. And disinterestedness among the framers, Madison and Hamilton, for them, disinterestedness was not aloofness, right? It was an ability to take oneself out of the equation and be a fiduciary, be an advocate, see the value for the community, right? To see what is in the best interests of everybody, right? And not necessarily to be a cutthroat advocate who will break the rules for to advance a client's interests, right? Number two, access. I think that we have to use as one of our North Stars, if you can have multiple North Stars, one of our North Stars, access to the profession and access to lawyers and legal assistance, right? And we can do that to a certain extent with advances in technology, right? And then third, inclusion, right? Inclusion. Now again, what our framers of our profession were trying to do at the turn of the 19th to 20th century was to create an inclusive profession as they saw it, as they saw inclusion, right? They weren't going to stop anybody from entering the profession, right? As long as they could jump through all these hoops, right? They also saw inclusion as bringing some of these communities that might, as the leaders of the bar said, might have a different experience with government, right? Might have come from communities, mostly what they were talking about was Southern Europe, where, you know, revolutions happened every other day and they don't have a belief in the rule of law, right? So they wanted to bring people into the American experience. So there was, again, strained as it might have been, there was, if you squint, you can see they did want inclusion, right? Of a certain character, right? So I actually think that those three principles, those three values, professionalism, access, and inclusion, are the values that should inspire us moving forward in the profession to help us transform our current institutions, to think about new institutions, maybe to get rid of some of those institutions, I don't know, right? But we have to come back to sort of basic principles, right? Why do we have a legal profession? And we don't have a legal profession to give lawyers jobs, right? We have a legal profession that has to support the rule of law, promote democracy, to promote a multiracial democracy that recognizes individual rights and is built on an adversarial system of justice, right? All of those things, right, are the values that the professions, institutions should strive to advance, right? And I can talk about, you know, some of the specific recommendations I have, but I do think that the broader sense in the book is to take a read on, you know, how we got to where we got to, right? Where we are now and where I think we need to go. So I'll stop there and invite questions. I don't know if I was just given, oh, this is our code. All right, so I should just say this for the folks online. Okay. Today's code is past 24. And I think I have to say it twice, right? Past 24. All right. All right. Oh, I got whatever. So I'm happy to take questions, happy to take comments. Is there anything? Well, you'll compile some stuff from the online. Yes, David, my colleague David Walker.
Right. It's interesting because you go back to sort of the beginning of legal education in America, and we talk about sort of like the small law schools and the offices. One of the reasons that people studied under lawyers and people went to Litchfield is actually for access to books, because law books were very limited, right? And so then we had a proliferation of publishing, and oddly, we're sort of in this situation with the ebooks that we're actually losing the ability to access content in ways that that might go unnoticed. So
I'm sorry, we're losing the ability
to access, and that's because of digital silos, that's because of paywalls, that's because number of things how publishers act. So in this future of lawyering, where does information play into this?
Oh, I think information plays a huge role. And you know, there was a significant shift. This same period as well, the 1880s, 1890s. You know, law firms. You know, someone hooked up a telephone in a law firm, right, in New York City, one of the big white shoe law firms, and the lawyers said, like, "What is that doing here?" Right? What's the telephone? You can communicate with clients. Well, what client is ever going to want to talk to their lawyer over the phone? And what's that machine? Oh, it's a typewriter, sir. What is it for? It's for typing letters and no, get that out of here. What client is going to want to receive a typewritten note? They want to see their lawyer's elegant longhand, right? Printing. So it was the late 1880s, 1890s that there's mass production of decisions, right? And so there was people, lawyers with more access to these decisions had a leg up into court. And so the old guard would walk into court and say, well, Your Honor, general principles. And the lawyers would say, actually, I disagree. There are some decisions where this court and the court above it actually made rulings. And so that access to information was a strategic advantage for the lawyers who did draw down the printed decisions, right, and had access to them. And so the limits on access to information can really constrain access to justice. And we're, to the extent that, AI is going to be used in the practice of law, it already is being used in the practice of law, no question, right? To the extent that more well-heeled, wealthier law firms can put the expense and time into building out AI models and protecting the information that they use through those AI models, and the nonprofits and smaller law firms can't do that because now it is actually expensive to get something that works well, right? We're going to see not a closing of the justice gap, but a widening of it. So access to information absolutely can undermine, or the lack of access to information can absolutely undermine access to justice. So it is a significant issue that we certainly have to be mindful of. And there are places where generative AI and other similar tools can actually work to close the justice gap, where there are, consumer debt. Let's talk about the consumer debt crisis in America. People are sued all the time for, small amounts of debt. In New York City, there's roughly 250,000 cases are filed in just a civil court in New York City every year on consumer debt. Those complaints are 1 page long. They're about 4 paragraphs long. Answers, should somebody actually answer them, and most of the time, no one answers those cases because they may not get it. They may not understand what it's about. Answers, to the extent they are filed, are also 1 page long. What are your defenses? I didn't get the complaint, right? So no personal jurisdiction. I don't owe the debt. I paid off the debt, right? There are not so many defenses, right? The debt buyer doesn't have standing to sue me. That's about it, right? You could imagine a digital interface that could close the justice gap in consumer debt cases, right? But we have to build it. We have to monitor it. It's not cheap, but we have to have access to that information and the ability to use those tools. So absolutely. So I would go beyond just information, but also the tools that can manipulate the information, that can work the information. Does that mean? There'll still be jobs for, just like legal ethics professors, there's still jobs for law librarians, David.
Yeah, because it doesn't work well yet. So
the AI, yes, because until it works well, exactly. That's right. That's right. Yes. Yeah. Use the microphone.
Oh, can you hear me? Just as kind of a counterpoint to that, and can't believe I'm kind of saying this, but there are still in this country, for example, family courts that are you're actually at somewhat of a disadvantage if you hire somebody outside of this very specialized system where the same players play all the time and know how to play the rules. If you hire, some of the worst cases I've ever inherited are people who had some outside lawyer who didn't practice family law and then went in because there isn't, it's its own little unique system that you are oftentimes, for better or for worse, kind of better off with particularly here because there's assigned counsel, but there's actually more, there isn't, I don't see, I've been saying this for years, maybe I'm wrong, but I don't as much see the AI and the kind of narrowing. I think that there are certain, well, maybe family court's the only one exception where it is still so much its own little world. And I mean, family court doesn't even take e-filing. And so there's a lot that is still, and it's not necessarily a positive, but it's a court made for people, pro se people, and the magistrates and judges write their own orders. Like it's not and when it gets infiltrated by outside and other technology and people do badly with lawyers who are higher paid who don't necessarily understand the underpinnings of the system. So I think it's kind of an interesting contrast. And I don't know whether it's better to bring family court more into the higher level or whether it's serving its purpose in some ways now by helping people who don't have access to those resources because they're actually better off. I mean, unfortunately, sometimes you look at people and you're like, you'd better off being pro se in this case because the magistrate understands and is, you just ask you direct questions. You don't need to be examined. Like you can just say what you want and they're kind of used to it. So it's just an interesting caveat to that.
Yeah,
I don't see that going in a different, I don't see family court getting more better for outside people.
Well, Bill Gates says that we overestimate the changes that are going to happen in 2 years and we underestimate the changes that are going to happen in 10. Right. And so I clerked in the Southern District in 1996. And at that time, there was no electronic filing. Right. And speaking of the last trial of the century, the OJ trial was going on at the time. And my judge really wanted to see the reading of the verdict. Right. And so she contacted the clerk's office in the Southern District and said, I really want a TV in my chambers. And the clerk of the court was like, TV in a judge's chamber that gets live television? How would one do that? And my judge said, I don't know, but you're going to figure that out, aren't you? And, when Constance Baker Motley told you to do something, you did it. And they did. And then the next thing that happened was that about, once news spread in the courthouse that Judge Motley was going to have a television in her chambers, we started getting calls. Oh, can I come down? Can I come up? And so there were about a dozen judges who watched huddled in Judge Motley's chambers to watch the verdict being read. And Judge Motley's husband, her name was Joe, it'll be relevant in a moment. So we're sitting there, we're all rapt attention. The verdict is read. All the judges, kind of like the 9 ring wraiths in Lord of the Rings, they kind of like stand up. No one says a word. They start sort of shuffling out. And not shuffling. That's unkind. They start moving it. No one's saying a word. You could have heard a pin drop. The phone rings, and Judge Motley says, "That'll be Joe. I owe him $5." And everybody started laughing. It cracked everybody up. But just think of that. When we used to get, the cases would be assigned to Judge Motley. We were on the wheel. She was senior at the time. We get a stack of papers, a stack of the cases once they were assigned to her. And sometimes the litigants lawyers would submit a floppy disk, right? Judge Motley didn't have a computer, right? The litigants would submit a floppy disk because our brief is so good, you're just going to want to download it to Windows 95, right? And put it right into the order, right? So the judge would say, like, what's this? And I'd say, oh, Judge, I'll take that. Don't worry about it. That's okay. I'll take care of that. But that's where we were, 30 years ago. Now, electronic filing, everything is done, in a very different way. So I agree, it's going to be hard for some courts to move into the future, into a world where a lot happens digitally. But here's where I draw some hope, right? Because the profession is conservative, it doesn't change, and small c conservative, right? It's not quick to change. If you had surveyed deans, judges, partners in law firms in January of 2020 and said, hey, how much do you allow your staff, your faculty, your associates to work remotely? Oh, I mean, once in a while. It's not like it's a thing, we don't really, not really allowed. We look the other way. Maybe we have a little bit of flexibility, right? And then, those same partners, and no offense, those same partners, several months later, were like, oh, wait, you mean remote work means I can work from Martha's Vineyard? Oh, wait, okay. And now I get it. Maybe this isn't so bad a deal, right? So we changed as a profession overnight, right, to adapt to a public health crisis. I think many of these crises that we face are just as serious, right? And we too, as a profession, can change, right? We did it, right? And I hope that we can do it again in some of these areas. Other questions? Yes.
Thank you, Dean Brescia. Really appreciate this very optimistic approach that you've taken in your book. Nearly 10 years ago, I was a law school applicant here at Albany Law School, and I heard a talk, you mentioning many of the principles that you've espoused this afternoon. So it's really great to see this work. Question for you.
Are you saying I repeat myself?
I'm saying that this is a work of art
Oh.
in the making. Dean,
Timeless. It's timeless. Yes.
that it is. Dean Brescia, quick question for you. So in looking at academic institutions, do you see academic institutions like Albany Law School and other law schools in New York actually responding in a way? So you say we need to transform as a profession, and you say how we should transform as a profession. Are our law schools teaching that transformation? Are we preparing students to go out into the profession to address some of the issues that we see and to really paint that beautiful picture going forward, what we need to see?
I like to think that we do here at Albany Law School, and others, my colleagues, Bella, we can ask any of the many students who are here, do you feel that this is an inclusive place? This is a place that's preparing you for the future? I'd like to think that we're trying, and that we are trying to prepare our students for the future. I think that we and every law school can do better, but I think we're trying to prep students for being professionals in a multicultural world, and to be prepared for the transformation that's going to come from technology, to be good citizens, to uphold the rule of law. I do think that that's what we try and instill in our students. So I'd like to think we're on that path. Is any institution perfect? No, institutions are created by human beings. No institution is perfect. There's more that we could do, but I do think we're moving, that we're on that path in the right direction.
If I may just add, so I employ Albany Law School graduates, and I can certainly see that. Albany Law School is an international example for that. Do you see, in your experience, whenever you travel to conferences or see other colleagues in the profession, do you see other law schools rising to that challenge as well?
I think certainly, I think that there are many law schools that are trying to do better, trying to be more inclusive, trying to prepare their students for the future, for sure, right? Are there some that are stuck in the ways of the past and want to cling to rankings this and whatever else is important to some other institutions? But I do think that there are schools that are trying to do the right thing. Yes.
Thanks. So I'm curious about what drew you to the idea of professionalism as one of your core areas of focus, because it feels like a word that's so capacious that it can mean anything from showing up in appropriate attire to defending the rule of law against totalitarian threats to following the rules of ethics. And I like the way you focus on understanding sort of the deeper duties of the lawyer. I think that's meaningful. But I'm curious about what it is that connects that to you to the specific crises that you mentioned.
Well, I think that using January 6th as an example, I think that the professionalism does not mean win at any cost, right? I was on a talk. I participated in a talk last week, and somebody said, well, the real crisis in the profession now is that, students have gotten, participation trophies. I'm like, what are you talking about? I said, no, I don't think the problem in the profession is that, new attorneys have been given participation trophies. And if you look at, it wasn't a lot of new attorneys who were in charge of the legal strategy, such as it was around January 6th. It was, the more seasoned attorneys, let's put it that way. And it wasn't about everyone gets a participation trophy. It was about winning at any cost, right? And so that's, that's at the ugly side of professionalism. And that's why I sort of said that disinterestedness, but in the sense of Republican virtue, again, small r Republican virtue, that you believe in the good of the community. But at the same time, it's an adversarial system. And we choose the adversarial system because we believe that that is what is needed to protect individual rights and for the system to change when it needs to change, right? So professionalism does not mean, you don't advocate for change, right? But you do so, right, in a way that you advocate using good faith arguments for the reversal, extension, or modification of existing law, right? That's what professionalism means in an adversarial system. And it does not mean that you make up facts, right? Like Jeffrey Clark saying to Acting Attorney General Jeffrey Rosen, I want you to send this letter to the legislature in Georgia, saying that the Department of Justice is investigating serious irregularities in the vote in your state, and you must put a stop to the certification process, right? Okay, if that were the case, if the Justice Department were investigating serious irregularities in the vote in Georgia, right, that might be something that the Attorney General might do, but it wasn't true, right? Even Attorney General Barr had said there weren't these problems, right? He stepped down, right? In steps Acting Attorney General Jeffrey Rosen. He says, no, right? We're not going to do that, right? That's professionalism, right? That's a man who knows he's out the door in a couple of weeks, right? He's going to be relieved of his position, but he's still doing the right thing, right? We need more of that. We need more of that. So professionalism, absolutely capacious, as you say, could mean a lot of different things to a lot of different people, right? But we have to think about what professionalism means for our profession in our democracy, right? Where we respect the rule of law and individual rights and operate in an adversarial system. Professor Rogerson.
On that note, and I had to ask what capacious meant. So.
What's that?
I had to ask what capacious meant. Full disclosure, first generation lawyer here. Lawyer Nation is made of people. And as strongly as I identify with you as being very proud to be a lawyer, one of the happiest moments of my life was getting the results of the New York bar exam bar none, even as it irritates my children to say that. How I've struggled to remind students and then peers that they were people before they were lawyers. For 20 years, they've been under the most optimistic of circumstances. And so I'm thinking about a book down the road around this idea of professional resiliency being something that we can teach and model in the profession. And in clinic, we do it by saying, in my clinic, you must bill 1 hour of your 10 to 12 to 14 hours per week doing something that I think is an ethical responsibility, which is to develop your own professional resiliency. Because as lawyers embroiled in conflict all the time, you hold all these buckets, you hold all of these privileges, you hold all these secrets, really. And when you're just a person, when your day is done, then what are you left with? And we think about addiction and substance dependency and mental health issues. Like, I'm very curious about, on that professionalism note, the idea of professional resiliency as an ethical obligation, and where you see us going with actually caretaking, as opposed to offering additional CLE credits for understanding addiction, for example.
Yeah, no, it's a great question. So I'm a big fan of Dan Pink. And I borrow from the framework that he's got in his great book, Drive, where, what motivates people? It's mastery, autonomy, and purpose, right? And so mastery of your craft as a lawyer, a degree of autonomy to do your work, right? And that you have some purpose greater than yourself, right? And I think that that's what some lawyers are missing, is that even if you're, working, in government, in the Department of Justice, if you're working in a court system, if you're working at a large law firm, a small law firm, you can find some purpose that connects to the larger whole, right? And just as, when I was a legal aid lawyer, when I was a legal services lawyer, I sometimes had to say to my client, no, right? I had to say, no, we're not going to have someone testify and lie. And yes, it might mean that you might lose your apartment, but like, I cannot lose my license over that, right? And that applies to someone, seeking to avoid an eviction, or someone seeking to avoid a conviction, or someone seeking to avoid a multi-billion-dollar fine from the FTC or something, right? The purpose greater than yourself is upholding the rule of law in an adversarial system, defending your clients, to the greatest, the best of your ability, but doing it in an ethical fashion as part of a larger whole. And that's the purpose. That's the purpose that I think that we've lost a little bit, that we have at times a win at all costs mentality, right? We have at times a, do anything, right, for the client, right? Zealous advocacy means doing everything, in support of the client's interests, even if it means violating the law or doing something unethical, right? And I think that that's something that I don't think a lot of lawyers think that way, but I do think that some lawyers are missing that purpose, that sense, no matter where they are in the system, right? They can have a purpose larger than themselves and act in a fashion that is consistent with their professional obligations, right? And sort of reclaim that purpose, and that professionalism. Well, thank you. We should wrap up soon, but Bella, I'll let you get the last word.
Well, I'll preface this by I wasn't alive in the boom of technology, the internet, or phones. I don't know how fast we had government regulations back then. But I do know that with COVID, it seems like almost instantaneous out of necessity that we got a lot of recommendations to help with Zoom and board meetings being online, all of these different things. How can we learn from the past to help now with AI so that it doesn't widen access to justice, but it actually helps work through that?
That's a great question. I think that and I think that there are people doing some really important work around this area, is sort of saying that, we made a mistake. We, US Congress made a mistake with the Communications Decency Act and Section 230, basically saying that, social media companies and other digital platforms could not be sued for improper, content posted on their platforms. I think that people are looking at that and saying that was a mistake, and we should not allow, some of, the companies who are doing the generative AI and other types of artificial intelligence. There has to be liability, that there has to be accountability, right? So I take some comfort in that we're having some of those conversations. Whether anything will actually get passed in Congress, I don't know. But, we have a legislature here that I think is open to some of these, some restrictions. The NISBA just produced a report on lawyers' use of artificial intelligence. So I think that we have, the bad experience of Section 230 to tell us that we need to be more mindful. And I do think that there's some effort afoot. We'll see what happens there. Thank you, Bill. But we rely on people like you to make these changes, right? Well, thank you, everybody. I really appreciate you all coming out. Thank you, everyone online.